following is a short video going over the structure of government and sources of law in the United States. Under the United States Constitution, there are three branches of government. The first is the Article I legislative branch, which is made up of Congress, and Congress itself is made up of the Senate and the House of Representatives. The second is the Article II executive branch, which is made up of the President, the Vice President, and those officials and offices that serve under the President or Vice President. The third is the Article III judicial branch, which is the U.S. Supreme Court and those inferior courts to the U.S. Supreme Court, such as the U.S. Court of Appeals and U.S. District Courts. The three branches of government work concurrently to implement law in America. Generally, Congress enacts law, the executive branch implements the law, and the courts interpret the laws. However, the courts also create law in making their decisions, and this is most commonly referred to as common law. The executive branch also creates laws through regulations, and like courts, they can also adjudicate matters, which can also be appealed to Article III courts. Additionally, Congress also has an adjudicative function in regards to high-level government officials, namely in cases of impeachment. And after the courts have interpreted laws, Congress can sort of clarify the interpretation through amendments to laws. However, everyone is bound to the U.S. Constitution, or what a majority of the justices on the U.S. Supreme Court say what the Constitution means. Now, like the federal government, South Carolina and all states in the Union has three branches of government. And like the federal government and its constitution, each branch of the state government is bound to the state constitution. Powers not enumerated by the federal constitution are reserved for the states. In turn, the states must afford much of the same constitutional protections granted by the U.S. Constitution. States can individually decide to give greater rights to those subject to its laws, but never less than those rights granted by the U.S. Constitution. However, the courts must determine whether a constitutional right applies to states through the 14th Amendment. Congress has limited authority to enact law. Public laws enacted by Congress are for the most part generally applicable. So, even while Congress might pass a law that only regulates the transportation of hazardous waste across state lines, which would really only impact those engaged in the shipment of hazardous waste, if any single individual or entity were to ship hazardous waste, they would be subject to that law. Thus, it would be generally applicable. However, the laws are only as good as the ability that exists to enforce them. Enforcement of the laws is done by the executive branch, and the executive branch is far more than just the president and the vice president. There are 15 cabinet officers who each head a federal department, which is then subdivided into various administrative agencies and offices. Then there are commissions, independent agencies, and federal corporations. Most administrative agencies are created by Congress. Administrative agencies fall under the executive branch, as their principal function is to enforce the laws of a particular jurisdiction, be it federal or state. Federal administrative agencies are created by statute, which is called the enabling legislation. The agency is then given the authority to implement the legislative scheme and basically carries out the purpose of the complex legislation in detail. Importantly, agency power is limited to the authority delegated to it by Congress. Administrative agencies have both judicial and legislative functions, even though they're part of the executive branch. For example, administrative agencies issue rules and regulations that carry the force of law. As part of their quasi-judicial function, they issue agency decisions and advisory opinions. They also create documents including guidelines, in-house memoranda, and reports. Laws resulting from agencies' quasi-legislative or rule-making functions are called regulations. They are far more detailed than statutes. Consequently, you always need to read the regulations in conjunction with any statutes they're designed to implement. Agencies can also act like the courts in their adjudicating functions, and decisions that arise from the agencies acting pursuant to their enforcement duties are needed to determine whether statute or regulation has been violated. Usually this involves the holding of a hearing, and usually initial agency decisions can be appealed to the agency itself. Under the judicial branch, there's both federal and state courts. Federal courts interpret federal law, the federal constitution, statutes, regulation, and federal common law, and state law under certain circumstances involving diversity of citizenship. The state courts interpret state law, the state constitution, statutes, regulations, and state common law. In law school, you will be looking at legislation significantly less than case law. And as you probably already know, case law is produced by the courts when they make a decision. Sometimes this is also referred to as black letter law. The courts adjudicate matters. They are the overseers of due process, and they ensure that proper procedures are followed and interpret what the law is in the jurisdiction in which they are appointed. The Article III federal courts are set up in a hierarchy. The U.S. Supreme Court is the highest court in the land, and it has appellate jurisdiction, which means that cases can be appealed to it, but it also has limited original jurisdiction in certain cases. The U.S. Courts of Appeals sit below the U.S. Supreme Court, and they have appellate jurisdiction, as made evident by their name. This means that lower court decisions can be appealed to this court. Finally, there are U.S. District Courts, and they have original jurisdiction, which means that the case can originally be brought before these courts. In South Carolina, we have the circuit courts, which are courts of general jurisdiction. There are 16 judicial circuits, 16 circuit judges assigned to them, and 46 circuit judges who rotate to these various courts. There's also magistrates' courts, probate court, and municipal court. The appellate courts in South Carolina are the Court of Appeals, which is made up of a chief judge and 8 associate justices, and the Supreme Court, who's made up of chief justice and 4 associate justices. Trial courts are courts of original jurisdiction, which means this is the first court that the parties would bring their claim to. They're usually presided over by one judge. Questions of law are decided by the judge. Questions of law are things like what exactly constitutes a burglary or what exactly constitutes a murder. Questions of fact are decided by a judge or a jury, and these are questions such as what exactly happened one night, was the person feeling in danger of their life, did they have a weapon, things like that. When judges decide questions of law, they will produce judgments or orders. In some instances, in some states, and at the federal level, trial courts may also write opinions. A judgment or order will directly affect the parties involved. The opinions offer reasoning behind their decision, and these are published to provide the reasoning behind a judicial decision so other people can follow it. Appellate courts, or the next court up from the trial court, usually only hear pure questions of law or mixed questions of law and fact. Parties can usually only appeal issues raised and decided on by the court below. Appellate courts usually create binding law, but any decision they make can be reversed by the court of last resort. Appellate courts spend most of their time behind closed doors. If a matter of law, or sometimes fact, is raised at the trial level, the losing party may file an appeal with the appellate court to re-examine the issue. Sometimes matters are decided on the papers, meaning that judges, usually consisting of a panel of 3 judges, read the briefs submitted by the parties and make their decisions based on the papers. Attorneys can often request oral argument. Appellate courts can often choose whether or not to hear oral arguments. Appellate courts may affirm the decision of the trial court, reverse, and usually remand the decision, which means to send it back to the lower court, or reverse in part and affirm in part. Usually an argument is scheduled so that judges can flush out issues which have been raised and not fully addressed by the briefs. Most oral arguments consist of a Q&A session where the attorneys answer the questions put to them by the judges. This is a map of the geographic boundaries of Article III courts. There are 13 circuits. 1 to 11 are shown on this map. There is also the DC Circuit and the Federal Circuit. Each state has at least one district court, although some states have more. For example, Tennessee has 3. However, South Carolina only has 1. South Carolina is in the 4th Circuit. Importantly, the published decisions from a particular circuit court are binding on everyone else in that circuit. So, for example, if the 4th Circuit decides that a criminal defendant in North Carolina does not have a First Amendment right to scream fire in a crowded movie theater, a judge sitting in South Carolina cannot say that he or she does have such a right. Jurisdiction is going to be important in legal research because it determines how much weight should be given to a particular decision. For example, a decision of the 4th Circuit will not bear as much weight in the 9th Circuit as it does on other courts in the 4th. The court of last resort is often the Supreme Court of a given jurisdiction, but not always. For example, in New York, the Court of Appeals is a court of last resort, and the trial court is called the Supreme Court. Usually, a court of last resort will only hear discretionary appeals. Consequently, lawyers have to file a petition to be heard. After the petition is filed, a judge may agree to hear the appeal or decline to hear the appeal. For the United States Supreme Court, approximately 7,000 petitions are filed annually. The court usually only takes about 70, or about 1%. Most importantly, the court of last resort's holding becomes the law of the entire jurisdiction. Under the doctrine of stare decisis, courts generally follow the decisions of previous courts. However, a court decision only has stare decisis effect if it rests on a legal point which is the same or substantially the same in both cases. To determine whether the questions are identical or substantially the same, the court considers the prior decision in the context of the facts and issues in existence at the time the decision was rendered. Thus, generally, if the facts between the two cases are different, stare decisis does not apply. When people talk about precedent, they mean prior cases with similar facts applying the same principle or rule of law. When people talk about primary law, they're talking about the law that is binding in a given jurisdiction. So, for example, South Carolina statutes in force are binding on South Carolina courts. South Carolina cases that have stare decisis effect are binding in South Carolina. And South Carolina administrative regulations are also binding in South Carolina. On the other hand, persuasive law is law that is not binding in a given jurisdiction. These may be cases from a lower court in the same jurisdiction, cases and statutes from other states, or possibly unpublished judicial opinions. As a general rule, the principle of stare decisis directs courts to adhere not only to the holdings of their prior cases, but also to the explanations of the governing rules of law. But for an opinion to have stare decisis effect, at least a majority of the members of the court must have joined in the opinion. However, a majority may be of a quorum rather than all of the sitting judges. Importantly, a minority opinion has no binding precedential value, nor does the opinion by an equally divided court. But if you're assigned these opinions in your reading, they're important because they may show you where the law is going or may provide you with counter-arguments to the primary argument made by the court. State courts are bound by decisions of the United States Supreme Court as to federal law. A United States Supreme Court decision regarding a question of the construction or application of the federal Constitution binds all state courts in interpreting and applying federal constitutional law. State courts are also bound by a decision of the United States Supreme Court as to the validity of state statutes under the federal Constitution, but they are not thereby bound to hold the statute constitutional under the state constitution. In law school, you're mainly going to be dealing with primary sources of law. A primary source is a statement of the law itself. This could be legislation created by a legislature, a rule promulgated by a federal administrative agency, or most likely, in your reading, you'll be reading the holdings of judicial opinions. Everything else is a secondary source, such as law review articles, restatements of the law, legal treatises, annotations, or legal encyclopedias. Primary authority refers to mandatory authority, or that which carries the force of law in a particular jurisdiction. These could be legislation created by the state legislature of the state you are arguing in, a rule promulgated by a federal administrative agency in a hearing before that agency, or the majority opinion of the United States Supreme Court in a constitutional law case. Everything else is secondary authority. Secondary authority does not carry the force of law, but it may be persuasive, such as concurring opinions, unpublished opinions, a law review article, or dissenting opinion. Ultimately, having these basic concepts in mind will help you with your study of the law.